Matthiesen, Wickert Lehrer, Austin, Texas office. I've been a licensed attorney since 2006. I originally grew up in Albuquerque, New Mexico, had moved down to Austin to attend the University of Texas. Subsequent to that, I moved to Houston to attend South Texas College of Law, where I graduated and took a job with a firm that did subrogation and defense work. Stayed with that firm for 3 years and then moved on to another firm in Houston that did exclusively subrogation work. I was with that firm for 5 years and then had an opportunity to come and serve as a supervising attorney for Farmers Insurance in their in-house subrogation department. I was brought up to Austin to really start that department and grow Farmers in-house subrogation department on the property and homeowners, as well as the auto side as well, which was a big success. I was with Farmers for about 5 years, and then when I learned that MWL was opening a Texas branch and happened to be in Austin, I ended up applying for the job and took the job with MWL. As I'm sure most people on this webinar know, MWL is one of the foremost law firms in the country when it deals with subrogation. I'm sure most everyone on here is very familiar with MWL's reference charts on their website. Everyone I speak with who does any type of subrogation work is very familiar with their website. So been here, our office has been open about 7 months, and we're just happy to be a part of the expansion process for MWL. Want to mention that, okay, that being said, let's get started with ethics for adjusters and attorneys in the claims handling process. So what is ethics? Ethics is generally a guiding principle of what is right and what is wrong. Ethics defined, Merriam-Webster definition, is the discipline dealing with what is good and bad and with moral duty and obligation. So professional ethics are the principles of conduct governing an individual or group. So long story short, it's what is good and what is bad with how we act in our professional world. One of the unique things about insurance adjusters is there's not a set ethical code in Texas that deals specifically with adjusters. Most other professions have some sort of code of ethics that will be filed and needs to be followed. Most of what this presentation touches on is dealing with ethics that attorneys deal with and how that will apply in your daily line of work as an insurance professional. Basically what it is hold yourself to the standard that attorneys are held to, and at that point you will be in ethical compliance with way to do things. So we had another video here, and without the sound it's not going to do any well, so we will just skip the video. This is a clip from the office dealing with Meredith doing some unethical behavior where she's trading favors with one of their vendors for lower prices on their goods. So apologize if the video audio isn't working. This is kind of a learning curve for us as well on this. Okay, so we have some common goals for insurance adjusters, attorneys, and experts in our daily dealings. So the common goals we have are to determine the actual reason for a loss or an injury and compensate the injured party in accordance with the law or a contract. And what that contract typically will be is the insuring agreement that your insureds have with the company itself. Another goal that we have is basically we are in a search for the truth. In every claims process, whether it be the beginning, the end, or your defense or plaintiff, we are searching for the truth to figure out what actually caused the loss, whether the loss is covered or compensable, and then on the back end, if someone else is responsible for that loss, if there's some way to maybe recover on that as well. So all parties need to be aligned in their basic goals, and this really is the underlying reason for having the basic rules of professional conduct. Again, as I mentioned earlier, they're basic rules that govern most every professional's conduct. So let's deal with competence. What is competence? Competence is essentially a qualification of someone to present the truth. And the Merriam-Webster definition is the quality or state of having sufficient knowledge, judgment, skill, or strength as for a particular duty or in a particular respect. So what that really means is you have to be able to use your skills, your knowledge, and your judgment to be able to execute your job in a manner which would be expected for the professionals under same or similar circumstances. So on the next slide, we will deal with the Texas Rules of Professional Conduct, number 1.01. Another video that no one's going to be able to hear, unfortunately. So the Texas Rules of Professional Conduct 1.01. So this is the first rule that lawyers deal with, and as such, the drafters of these rules of professional conduct made this number one, which to me tells me it was a very, very important rule, and one that they made sure that all lawyers knew. So it states a lawyer shall not accept or continue employment in a legal matter which a lawyer knows or should know is beyond the lawyer's competence, unless one, another lawyer who is competent to handle the matter is, with the prior informed consent of the client, associated in the matter, or the advice or assistance of the lawyer is reasonably required in an emergency, and the lawyer limits the advice and assistance to that which is reasonably necessary in the circumstances. So what the rules are saying is that lawyers need to be competent to handle a matter. And basically what it's boiling down to is if you're a lawyer who handles civil cases, it's probably not the best idea for you to take on a capital murder case, especially if you don't have any skill, training, or knowledge about the criminal justice system. Again, there is an exception here under subsection 2 that the lawyer can assist if reasonably required in an emergency, and that the lawyer limits the advice and assistance which is necessary under the circumstances. That's a very narrow guide, but it allows for lawyers to help out. Any lawyer would know that in the event they had some sort of emergency situation pop up such as this, as soon as thereafter they would try to bring in another lawyer who would be competent in that particular area of the law. So let's move on to the comments. And the comments within the rules of professional conduct are our guiding principles, and this is really what's going to apply as we make these rules applicable to the insurance adjusters. So competence is defined in terminology as possession of the legal knowledge, skill, and training reasonably necessary for representation. Competent representation contemplates appropriate application by the lawyer of that legal knowledge, skill, and training, reasonable thoroughness in the study and analysis of the law and facts, and reasonable attentiveness to the responsibilities owed to the client. So what's this application to insurance adjusters? So adjusters need to be competent in their skills of whether they are working on an auto case, whether they are working on a homeowner's case, and whatever that the area that you're servicing your clients. So it's imperative that insurance adjusters attend training, that they execute their knowledge, and that they keep up with their skills to make sure that they can comply with the responsibilities that they owe to your own insureds. And we'll get into that a little deeper as we move forward. So let's look at the truthfulness. So Texas Rules of Professional Conduct, Rule 4.01, state for lawyers that in the course of representing a client, a lawyer shall not knowingly A, make a false statement of material fact or law to a third person, or B, fail to disclose a material fact to a third person when disclosure is necessary to avoid making the lawyer a party to a criminal act or knowingly assisting a fraudulent act perpetrated by a client. So what this means is that lawyers really have a duty to tell the truth. And also that lawyers have a very severe duty to make sure that a party is not perpetrating a fraud or allowing a criminal act to occur by knowingly assisting. And this issue is raised for insurance adjusters because, as I'm sure anybody that's been doing this job long enough knows, there is such a thing as insurance fraud out there. Not everybody's honest. So if in the course of your servicing your clients and you may realize that a fraudulent action or that insurance fraud, is ongoing, at that point, as an adjuster, you then have a duty to make sure that that's investigated, whether that be chatting with outside or in-house counsel, your managers, or SIU team. But at some point, if you do have a good faith belief that insurance fraud is occurring, you have a duty to make sure that that fraud does not keep on going. So again, we'll look at some of the comments here under the rules of professional conduct, again with 4.01. Comment 3 states, generally, in the course of representing a client, a lawyer has no duty to inform a third person of relevant or material facts, except as required by law or by applicable rules of practice or procedure, such as formal discovery. So what this means is that an attorney, although they have the duty to tell the truth, they don't have to give up their case to the other side. Unless, of course, there's formal discovery or you're in front of a judge, then you obviously have the duty of candor for the truth. But basically, this comment is saying that the other side also has a duty to investigate and determine their own facts. It's not as if you have to give up everything on the front end to do this. And how this applies to insurance adjusters is in the course of your investigation on losses, you don't have to turn everything over to the other side. You can investigate your facts, allow them access to investigate a loss scene, interview witnesses, that kind of thing, and let them make their own conclusions. So again, obviously, if you are hit with a discovery request or you're under oath on deposition, that's a whole different ballgame. But let's go on to comment 5. A lawyer should never knowingly assist a client in the commission of a criminal act or a fraudulent act, which we went over again a little bit earlier, that if you do believe there's some sort of insurance fraud going on, you do have a duty to make sure of this. And a key on this is knowingly. So if an attorney or an adjuster doesn't knowingly assist a client, then they're not going to be doing anything wrong in the eyes of the ethics board or of the law. So seeking the truth is a means to dispute resolution. And what we are doing in the insurance world is we are basically resolving disputes, whether that be between an insured and their insurer, whether it be between an insured and someone who may have caused the loss, or whether it may be between two insurance companies who are trying to determine who is actually covering a loss and who's responsible. So dispute resolution is basically seeking out the truth. And it's so important that even the United States Supreme Court in 1966 weighed in with the statement of the basic purpose of a trial is the determination of truth. Now, this applies on both civil and the criminal aspect, but the reason we have trials and litigation, and included in the definition of trial should be all the investigation and litigation, is that we are looking to determine the truth. So, good faith. I want to move into good faith, and here in the Texas Rules of Professional Conduct, 3.01 deals specifically with good faith. So, they state a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless the lawyer reasonably believes that there is a basis for doing so that is not frivolous. So applying this to the everyday world, if you decide to pursue a claim against another party, as long as you have a good faith basis that the facts are somewhat in your favor, you are allowed to proceed on this. It means that not every case you are going to bring is going to be a slam dunk. Obviously facts change and witnesses change, and there's two sides to every story. So the defense here may think that your case is frivolous, but if you can show a good faith basis for going after or defending, on the other end, a claim, you're going to be in compliance with the law. I mean, again, the reason we have all this stuff is we are seeking to boil down and get the truth out. That process is going to occur in investigation, discovery, trial, witness testimony. And so obviously it's impossible to know what everybody's going to say and at the beginning of a claim. So as the claim moves further on in its proceeding, you will learn more of the facts and apply more of that too. So let's look at some of the comments here on Rule 3.01. A filing or contention will be considered frivolous if it contains knowingly false statements of fact. It is not frivolous, however, merely because the facts have not been first substantiated fully, or because the lawyer expects to develop vital evidence only by discovery. Neither is it frivolous, even though the lawyer believes that the client's position ultimately may not prevail. In addition, this rule does not prohibit the use of a general denial or other pleading to the extent authorized by the applicable rules of practice or procedure. So let's apply that to the insurance adjusters, the insurance professionals. As long as a lawyer signs a pleading that does not knowingly contain false statements, the pleading is going to be valid. Same thing here with the adjusters, that if you believe that there's a basis to either defend or seek recovery on a claim, as long as you've got that are not knowingly false statements within there, you are good. Excuse me, you are good to proceed on that claim. Again, the pleading will not be considered frivolous because all of the facts have not been fully investigated, or that the lawyer thinks that some of the evidence will come from discovery. A perfect example of this is, excuse me, if you believe that a defendant in an auto wreck maybe ran a stop sign, well, that defendant's probably not going to give your company a statement on the front end But if you have a good faith duty that Donnie defendant ran the stop sign and that your evidence will show this later on in discovery, then you are okay to proceed on that claim against Donnie defendant, knowing that you may get the facts out in his deposition. If there's enough fact evidence to be a toss-up of whether or not you ultimately win the case, that's still okay to proceed on. You don't have to bring a case only if you think you're going to be a winner. And then, the general denial comment here for the folks on the defense end is that, in U.S. courts, the plaintiff has the burden of proof. It's up to them to prove to the judge and the jury why they should win. So the defendant doesn't have to marshal all of their evidence. They can simply use a general denial and say, okay, let's shift the burden over there to the plaintiff and let them figure out how to win the case or convince the trier of fact that they can win the case. So quickly right now, we are going to make sure everyone's still with us, and I'm going to go ahead and ask the trivia question. Again, please respond through the question pane on your dashboard, and then the first one to answer correctly will win that MWL book of choice, and Jamie Breen will get with you on that. So the trivia question for today: where is the southernmost point in the United States located? Again, where is the southernmost point in the United States located? First one to answer will win that book. And we will announce the winner at the conclusion of the presentation. Okay, something that really tailored to the insurance professionals here, and something I'm sure everyone deals with on a daily basis, is the unfair settlement practices. And the Texas Insurance Code specifically deals with this. I'm sure everyone has read and dealt with this provision in the past, but here's what it states. Section 541.060. It is an unfair method of competition or an unfair or deceptive act or practice in the business of insurance to engage in the following unfair settlement practices with respect to a claim by an insured or beneficiary. 1, misrepresenting to a claimant a material fact or policy provision relating to coverage at issue. What that means is that you cannot misstate the coverage is within an insuring agreement. The agreement and the policy is what's going to control. You have to understand that your customers here have paid for certain coverages under their policy, and what that policy says within the language within the policy says is going to control. So you are not allowed to misrepresent the policy provision relating to a certain type of coverage under that policy. 2, failing to attempt in good faith to effectuate a prompt, fair, and equitable settlement of, quote, a claim with respect to which insurer's liability has become reasonably clear, or a claim under one portion of a policy with respect to which the insurer's liability has become reasonably clear, to influence the claimant to settle another claim under another portion of the coverage, unless payment under one portion of the coverage constitutes evidence of liability under another. So I'm sure everybody here has dealt with, and I'm sorry my computer is going off on the thing. I will scoot back to that one so we can explain it. Okay. So what number 2 means is that, and I'm sure most people here have dealt with this plenty of times, sometimes you have auto insurers who you've got a favorable police report, you've got witness statements, you've got everything that lines up for being in your favor, and you end up getting a denial of a claim, despite the fact that it's pretty clear that liability is there and that they are just delaying the claim for unreasonable purposes. So this is actually in breach of the insurance code. The issue we have here in Texas is that there's no such thing as third-party bad faith. So, it may be that a company is breaching the insurance code, but as someone who's being affected by that, unless you're the policyholder, there's really not a whole lot you can do other than hope they do the right thing eventually. But know that they are, in fact, doing this. And I urge anybody in here that, if it does look like you owe a claim or that your insured is liable to another claimant for the claim, that you get the claim paid. That's going to prevent headaches down the road. It's going to prevent your particular insureds from being sued, and it's going to really prevent any possibility of your insured coming back and saying, hey, I ended up getting sued because you guys failed to effectuate a settlement when liability was clear, and it's had an adverse effect on my life. So number 3 under this code provision, failing to promptly provide to a policyholder a reasonable explanation of the basis of the policy in relation to the facts or law for the insurer's denial of a claim or offer of a compromised settlement of a claim. So what this means is that when you are either denying or settling out a claim, it's best to get on the phone or put in writing, a safer bet, but communicate with your customers and explain to them why it is that a case is either being denied or the settlement is occurring. If it gets escalated from there, at that point you may want to involve coverage counsel to get something formal and in writing to make sure that you are preventing you and your company from being accused of bad faith. But again, we go back to what kind of the underlying theme of this presentation is, and that's truthfulness. So as long as we're speaking the truth and we're giving people rational explanations and justifying why we are taking an action which will have an effect on your insured, we make sure that when we're being truthful that they know why and that we're being open on that. Okay, the next provision, number 4, is failing within a reasonable time to affirm or deny coverage of a claim to a policyholder or submit a reservation of rights to a policyholder. So, we can't string along our insureds for too long. If you are doing a coverage investigation as to whether or not a certain loss may be covered under a policy, you need to, within a reasonable time, either tell your insured that yes, there is coverage, or no, there is not coverage. And if you are not able to do so in that reasonable time, submit a written reservation of rights to them. Make sure that it's mailed, traceable, that they have a copy of it, email, fax, however you can get it to them, to make sure that they've got that. Because what you want to do is make sure that if something comes up and you're accused of bad faith, that you're able to show the Department of Insurance that you did in fact comply with this code provision, and within a reasonable time you either affirmed, denied, or submitted a reservation of rights that you were going to investigate the coverage further on this loss. Provision 5, refusing, failing, or unreasonably delaying a settlement offer under applicable first-party coverage on the basis that other coverage may be available or that third parties are responsible for the damages suffered, except as may be specifically provided in the policy. So what this is saying is, let's say that someone rear ends your insured, your policyholder, and it's clear that the other person is at fault. You cannot delay the offer to your insured by simply saying, well, the other guy's insurance should pay for this. Your customers have paid for the coverage. If they wish to use it, they are free to use it. And it's bad faith to deny them the coverage that they've paid for and the coverage that you have contracted to provide to those folks. If you've got a responsible party and paying the claim, that's where subrogation counsel comes in. As the subrogation counsel will go ahead and recover the money that you pay out. So, the whole system is set up to make sure that your insureds are made whole and that their damages are covered as quickly as possible so that they can move on with their lives. The next provision, number 6, undertaking to enforce a full and final release of a claim from your policyholder when only a partial payment has been made, unless, of course, that payment is a compromised settlement of a doubtful or disputed claim. So a long way saying it, you can't ask your insureds to waive their own rights under the policy if they have only been partially reimbursed for everything. So in maybe the homeowner's context, if they are still in temporary housing while their home is being repaired, let's say maybe from a flood, you can't have them sign a final release of their claim if they're still in that temporary housing, and they're still going to be incurring those additional living expenses. Number 7, refusing to pay a claim without conducting a reasonable investigation with respect to the claim. This seems pretty elementary, but it is imperative that when a claim is made, that you as a professional do your diligence and your truth-seeking duties to conduct a reasonable investigation into the facts of a loss which gave rise to that claim. And then number 8, with respect to a Texas personal automobile insurance policy, delaying or refusing settlement of a claim solely because there's other insurance of a different kind available to satisfy all or part of the loss forming the basis of the claim. Where this is going to come up is, you've seen this, I'm sure, is some folks will have multiple coverages on their automobile. They will maybe switch insurance companies, or they'll get an additional policy on their car, or maybe there's a business policy that also applies. But whatever it may be, you can't, as an insurer, just say, well, there's another company that provides the coverage, go to them. Again, this is where subrogation counsel and the dispute resolution process will take over. That it's kind of better safe to pay the claim and then figure it out on the back end. Let the two insurance companies figure it out amongst themselves. There may be coverage issues depending on whether a person was within the course and scope of employment or not. But getting the claim paid and then letting the insurance companies figure it out between themselves is going to keep your policyholders happy, because the claim has been paid quickly. And then, as I'm sure everyone here knows, the quicker a claim is settled, the happier your customer is, and the happier your customer is, generally the longer term of a customer they're going to be with you. So if your claims get paid promptly, the customer is going to stick with your company more than likely. And they're also going to talk to their family and friends and say, hey, ABC Co. did such a great job with my claim. I'd highly recommend using them in the future. So another video, sorry we can't hear it. We're going to get that fixed next time, but this one deals specifically with the Incredibles, and he's working as an insurance adjuster, and he's denying a poor old lady's claim, but he's helping her, saying, hey, here's how to make sure that the claim gets paid under your policy. So let's look at unfair settlement practices. This is a big one in the insurance world. So this specifically deals with auto and obtaining a deductible reimbursement on an auto loss. And the legislature decided that this was so important that they decided to codify this. So insurance code 542.204 is entitled the action to recover deductibles. So it reads, notwithstanding any other provision of this code, and except as provided in subsection B, which we'll go over, if an insurer is liable to an insured for a claim that is subject to a deductible payable by the insured, and a third party may, here's the key word on this one, may, be liable to the insurer or the insured for the amount of the deductible, the insurer shall. So if someone's may be liable, the insurer shall. This is a requirement. One, take action to recover the deductible against the third party not later than the first anniversary of the date of the insured's claim is paid, or pay the amount of the deductible to the insured. So what this means is we'll go to just the simple rear end accident. So if your insured is rear-ended, they make a claim on the policy and they pay a deductible as part of that insuring agreement. At this point, you as the insurer have a statutory and legal duty to take an action to recover the deductible against that third party. And you only have 1 year from the date the insurance claim is paid, or you can simply refund the full amount of the deductible to your insured. And we'll go into the exceptions on B, which we've discussed, or we'll discuss now. So subsection B says an insurer is not required to take action or pay the amount of the deductible as required under subsection A if not later than the earlier of the first anniversary of the date the insurance claim is paid, or the 90th day before the statute runs. The insurer does the following: notifies the insured in writing that the insurer does not intend to take further collection actions against the third party, and then authorizes the insured to take further collection action. So what's this saying is that once the insured's claim is paid, we have a 2-year statute here in Texas, so usually going to be the first date, the 1 year, not the 90th day before the statute expires, unless we've got a disputed claim. But you need to notify your insured in writing that, hey, Mr. or Ms. Insured, we are not going to take any further collection action against that potential third party. And as part of that letter, you also have to say, and Mr. and Ms. Insured, you are authorized to take further collection action. So you are essentially turning over the policy or the ability to collect from that third party to your insured. Key on this section, and this is a very big one that comes up a lot, and we get a lot of questions on this. This section applies regardless of whether the third party who may be liable for the amount of deductible is insured or uninsured. I'm sure as anybody who's ever done auto collection work knows, uninsured motorist work is some of the most difficult work that we can do in the subrogation world. The collection rate on it is very slim, but there is a legal duty for insurance companies to either comply with subsection B of 542.204 or comply with subsection A and seek recovery of that deductible from that uninsured motorist. Okay, one of the last things we want to go over with is communications with represented clients. So back to the rules of professional conduct. Rule 4.02 states, subsection A, in representing a client, a lawyer shall not communicate or cause to encourage another to communicate about the subject of the representation with a person, organization, or entity of government the lawyer knows to be represented by another lawyer regarding that subject, unless the lawyer has the consent of the other lawyer or is authorized by law to do so. What this means is that if you know that someone else is represented as we apply this to lawyers and insurance adjusters alike, make sure that all communication goes through that counsel. I know that on the bottom it says unless the lawyer has consent of the other lawyer. I take the better safe than sorry approach, and I direct all communications through that lawyer every time until it's a point that maybe the lawyer on the other side gets frustrated with you keep contacting them and they send you something in writing. I would make sure you have something in writing that says, I, attorney for the person here, give you express consent to communicate with my client. That's going to be a very rare occasion that's going to occur, but again, it's better to take the safe than sorry approach to this and make sure that if someone is represented that you deal with that counsel specifically. Subsection B, in representing a client, a lawyer shall not communicate or cause another to communicate about the subject of representation with a person or organization a lawyer knows to be employed or retained for the purpose of conferring with or advising another lawyer about the subject of the representation unless the lawyer has the consent of the other lawyer. So again, this is just expanding. You can't even speak about the subject of the representation or why that attorney is representing him. Again, if you know that someone is represented by counsel, direct all communications through counsel. And this even applies to your own insured. So if your insured is in, let's just say, a simple auto accident and they've had some injuries and they are represented by counsel, you should not be communicating, even if it deals with their rental car and whether they were satisfied with the type of rental car they got from the rental car agency. Don't call your insured. If they've got a lawyer who's representing them for any part of that case, go through that attorney directly. And if it turns out that the attorney eventually says, hey, you can talk to your own insured about, certain parts of the loss, request that lawyer send you an email in writing specifically saying what you can communicate with your own insured about, and really try to limit any communications to that scope. And if your insured decides they want to go off of that script and go outside of what the lawyer authorized, just shut it down. Just say, hey, listen, I've spoken with your attorney. Your attorney who is representing you has told me we can talk about certain subjects. I feel like this is getting off that subject or off that topic. I'd be more comfortable with your lawyer on the phone or communicating with your lawyer. So again, it's just going to save headaches for you and for your company moving forward. And that, again, if they are represented, the right thing to do is allow that representation to speak for that person. So I want to just go over a quick recap as to what we're doing on this presentation and what we were looking at. I know it was a lot of information on ethics. So we're always looking to do what is right. In order to do what is right, we need to be competent in our professional duties, and that competence comes from our knowledge, skill, and training. While doing what is right, we are also seeking to determine the truth, which again is the basic for the entire claims and trial process, from the date a claim is opened until whether it goes through trial and a verdict. We are always seeking to determine the truth by doing what is right. Part of our quest for the truth is to be truthful in our dealings with others. This includes our insureds and our clients. We need to act in good faith in our dealings with the insureds, with adverse parties, courts, other claims professionals. What this means is, do the right thing. If you've got reasonable basis for pursuing a claim, pursue it. But, be civil to each other. I mean, this is really just a being civil type deal. Continuing on, we are looking to avoid bad faith via unfair claims settlement practices. And, for those of us in the auto world, we have a statutory duty to recover deductibles, even if the tort fees are is uninsured. And then last, what we talked about is avoiding communications with represented parties. This includes your insureds, adverse parties, experts, witnesses, anybody who is involved. So briefly, before we get to the questions, I just want to make quickly everybody aware that some of the resource tools, that we have on our website. If you've not visited MWL's website, I would highly recommend you doing so. The address is noted here on the slide, as well as my contact information. But the website is packed with resource tools that are no cost to you. Namely, we've got reference charts that cover a variety of topics for all 50 states, including MedPay and PIP subrogation, suspension of driver's licenses, loss of use, diminution in value claims, comparative fault laws, statutes of limitations. We've got a map on the website that does specific laws by state. You can click any state and get all the laws related to that. We also have an Ask a Question feature where you can ask a question and it goes to Gary Wickert, the head of our subrogation division. That would be answered typically within 24 hours. Most often it's a lot sooner than that. And then we've got some questions that have come in. If you've got some questions, please feel free to ask them and we'll get to them. Again, we will get to as many as we can. And if we don't get to them, we will email you with a response as soon as we can. So the first one I see coming in is, what do you do if a party is represented, but their counsel refuses to respond to you? As I'm sure most everybody has had this come up in the past. You know that you've got an insured or someone else who has other counsel. If they refuse to respond to you and you're trying to get them and it's holding up your investigation, send them a letter, send them emails, get them an actual written letter that shows they received it, asking them to contact you directly. If within a week or two you still don't get a response, I always like to, at that point, send a letter that just says, hey, listen, we've made a good faith effort to contact you. We can only surmise by your lack of a response that you may no longer be representing this person. If I don't hear from you within a reasonable time, 2 weeks is probably reasonable. Within a 2-week period of time, that we will guess that you're no longer representing that client. If you've done a good faith duty to go through that counsel, then you're not going to get in trouble. There's not going to be any wrongdoing because you're doing what you think is right. So again, it's really being reasonable and doing what you think is the best case scenario. And again, if you ever have any questions on this, chat with someone who's done it, whether it be a manager or an attorney. Reach out and ask them what you think would do and get the advice. Just don't act. So next question we've got here deals with, I guess, the settlement. Is it true in Texas that carriers can settle out claims on a first come, first served basis? That is true. So Texas is kind of a unique state in that we are allowed as insurers to settle out claims as they are made. So, if you've got a multi-car pileup, the first car makes a claim against the responsible party. It is not bad faith for the insurer to pay that first claim. It may be a bad business practice knowing that maybe there's a 4-car pileup, but you can pay that first claim off that comes in. Or it may be that you have a claim and a claimant comes down the road 6 months later, but you've paid out your limits. That's not going to be considered bad faith. And, the rationale behind that in Texas is that if you can get a claimant to go away by settling a claim that is owed, you're going to avoid a lawsuit down the road. Certain states don't take that same approach. Certain ones say, if you just pay the first claim, you're opening up your insured to additional liability. That's kind of two global views of looking at it. can't really say either one is right or either one is wrong. So last one we've got, we're running out of time. I don't want to go over the full hour here. It says, is there anything we can do when another carrier is failing to pay a claim where liability has become reasonably clear? And we touched on this earlier in the presentation. There is no such thing as third-party bad faith in Texas. And what that means is if, let's just say someone rear ends you and the other side reasonably owes the claim. If they don't pay that claim, you as the injured party don't have an independent cause of action against the other person's insurance company. And the reason being is that, you don't have a contract with them. You're not their customer. There's no privity of contract. So there is something we can do. I mean, you can always send a demand. As attorneys, what we like to do is, we'll send a demand directly to the person who struck you and say, hey, listen, your insurance company is refusing to pay this claim. It's one that it's clear you are liable for, and that time you might want to threaten litigation. Generally, that'll spur a call from the responsible party to their own insurer to say, hey, what are you doing here? I'm getting threatened with a lawsuit on a claim where I'm at fault. A lot of times a strongly worded letter and getting an insured to call their own insurer and ask them what's going on is a good way to get the claim moving forward and get resolved. So I am just right at our 1 hour minute, or 1 hour time. Want to make sure that we announce the winner of our trivia question is Carolyn Phillips. Carolyn, congratulations. The correct answer is Hawaii. I'm sure many people said Florida, but if you look at the map, the southern tip of Hawaii is further south. So Carolyn, congratulations. I want to thank everybody who attended this webinar. We've got, I think, over 1,000 people who have attended. Again, I apologize for the video not being there. It makes an ethics presentation a little more entertaining. We'll get that worked out on the next one, but I want to encourage that if anybody has any follow-up questions to this webinar, please shoot me an email or give me a call, and I will answer any and all questions that we can. And again, if you have any other subrogation questions or issues come up in the future, please feel free to give us a call. Thank you guys again. Have a good day.